Delmo, did you read everything about Rule 30 of the Rules of Court?
Yes, attorney.
Stop smiling. Now, Section 1, Rule 30 states that the parties shall strictly observe the scheduled hearings as agreed upon and set forth in the pre-trial order. Now, Ms. Delmo, how does the schedule of the trial dates take place?
According to paragraph A, section 1, Rule 30 of the Rules of Court, the schedule of the trial dates for both plaintiff and defendant shall be continuous and within the following period. First, the initial presentation of plaintiff's evidence shall be set not later than 30 calendar days after the termination of the pre-trial conference. Plaintiff shall be allowed to present its evidence within a period of 3 months or 90 calendar days, which shall include the date of the judicial dispute resolution if necessary. The initial presentation of defendant's evidence shall be set not later than 30 calendar days after the court's ruling on plaintiff's formal offer of evidence. The defendant shall be allowed to present its evidence within a period of 3 months or 90 calendar days. The period for the presentation of evidence on the third, fourth, etc. party claim, counterclaim, or cross-claim shall be determined by the court, the total of which shall in no case exceed 90 calendar days. If deemed necessary, the court shall set the presentation of the parties' respective rebuttal evidence, which shall be completed within the period of 30 calendar days.
Okay, sit down. Now, discuss paragraph 2, section 1 of the Rule 30 of the Rules of Court. Ms. Bugayong.
Paragraph B states that the trial dates may be shortened depending on the number of witnesses to be presented, provided that the presentation of evidence of all parties shall be terminated within the period of 10 months or 300 calendar days. If there are no third, fourth, etc. party claim, counterclaim, or cross-claim, the presentation of evidence shall be terminated within a period of 6 months or 180 calendar days.
You really read your codals. Now, Ms. Pareño, recite to us paragraph 3, section 1 of the Rule 30.
Paragraph 3 states that the court shall decide and serve its copies of its decision to the parties within the period not exceeding 180 calendar days from the submission of the case for resolution with or without memoranda.
Are you sure?
Yes, attorney.
I'm not done yet. Are you sure? Remain standing. Ryan,
Yes, attorney.
do you agree?
Attorney, I think...
You think? That's what you think. That's your opinion. Well, you think nothing. I don't care about what you think, and I don't care about everybody's opinion. You, just give me an answer.
No, attorney. The court shall decide within 90 calendar days from the submission of the case for resolution with or without memoranda.
Good. Now, tell us about the case of Morales versus Mangubat.
Attorney, in the case of Morales versus Mangubat,
Ryan, newly relocated to General Santos City for work, spent the whole day searching for an apartment. Unfamiliar with the area, he struggled to find a place, until he finally came across one owned by a local named April.
Yes?
hello, good morning, ma'am. My name is Ryan, and I'm looking for an apartment. Are you the owner of this apartment?
Yes, I am the owner. Are you looking for an apartment?
Yeah, that's right. May I know how much is the monthly rent?
It's 5,000 pesos, but that's excluding the water bill and the electricity bill. And you have to pay a 1-month deposit and 1 month advance.
Okay. I think it's reasonable for the rate. Yeah, I'll take it, ma'am.
All right, then let's go inside. And by the way, you need to sign a contract. just to make sure that you're going to pay the dues.
Yeah, okay. No, no problem.
Ryan! Ryan! Ryan, come out! It's been months since you haven't paid your rent! Ryan!
Why are you so loud?
Me? Loud? Months! Many frustrating months, Ryan, since I have not received any payment from you.
I know, and I will pay you when I have the money.
No! I demand you to vacate this apartment!
You can't do that.
Of course I can! See?
Ryan didn't think about what he left behind. The unanswered messages, unfinished tasks, or the noise of his daily life. Out here, it all felt unimportant. This trip wasn't just a break. It was a release. He lived every moment like it was his last. Little did he know, a demand letter had already been sent by April. While he enjoyed the present, the consequences of his actions were already starting to catch up. April consults attorney Shandee to seek legal assistance in filing a civil case for unlawful detainer against Ryan, who refuses to vacate the property despite repeated demands.
Hello, Ma'am April. Good afternoon. This is Attorney Shandee, your counsel. I wanted to inform you that the trial has been postponed. The judge granted the motion and proceedings will be temporarily delayed. I understand this may cause some frustrations or uncertainty, but rest assured, this is only a pause, not a setback. In the meantime, we'll stay prepared. Use this time to rest, to reflect. I'll keep you updated the moment we have a new date. For now, take care. We'll move forward soon. Yes po, ma'am. Sige po. Thank you po. Sige po. Bye-bye.
We are now proceeding to trial in civil case number 2025-MTC-037, Morales versus Mangubat for unlawful detainer.
Appearances of the counsels.
May we please the court, Your Honor. Good morning. I am Attorney Shandee Bugayong, appearing as the counsel of the plaintiff.
May we please the court, Your Honor. Good morning. I am attorney Belle Yatar, appearing as the counsel of the defendant.
We call Miss April Morales to the stand.
Okay, you may take the stand.
Miss Morales, can you state your relationship with the defendant?
I am the owner of the apartment unit. He is renting from me.
Do you have a contract?
Yes, a written lease agreement which he signed January 1, 2023, and it's a one-year contract.
Do you recognize this document I am showing to you marked as Exhibit A?
Yes, that's right. This is the contract signed between me and Mr. Mangubat on January 1, 2023.
When did the defendant stop paying rent?
He last paid in June 2024. After that, he remained in the property without paying.
Did you serve a demand?
Yes, in November 2024. So I even gave him 15 days to vacate or settle his dues.
Do you recognize this document marked as Exhibit B?
Yes, this is the demand letter I sent to him. But he just ignored it and still stayed without paying.
What release do you seek?
I want possession back and to recover the unpaid rents.
Miss Morales, you mentioned a demand letter. Was it personally received by Mr. Mangubat?
Yes, Your Honor, I personally handed it to him.
And do you acknowledge he made partial payments?
Well, he gave 3,000 pesos in July, but not the full monthly rent.
Mr. Mangubat, did you occupy the unit as a tenant?
Yes, since 2023.
Why were you unable to pay rent?
Actually, I lost my job in March 2024 and I requested consideration from Ms. Morales and she agreed verbally.
Did she ever tell you to vacate personally?
No, but she gave me a demand letter to vacate.
You admitted non-payment. Do you have proof of any formal agreement allowing you to stay rent-free?
No written agreement, attorney, but only verbal conversation.
So, you admit overstaying in the property without paying full rent?
Yes, but I asked time. A trial is deemed submitted for decision.
That's enough. Sit down. Now, ruling, Miss April.
The court ruled in this case that
This court, after having carefully examined the evidence on record, the testimonies of the parties, and the applicable law, now renders judgment in this unlawful detainer case filed by plaintiff April Morales against defendant Ryan Mangubat. It is undisputed that the parties entered into a written Accordingly, the court finds that the plaintiff has established a case for unlawful detainer under Section 1, Rule 30 of the Rules of Court. Wherefore, judgment is hereby rendered in favor of the plaintiff as follows. Ordering the defendant Ryan Mangubat to vacate the leased premises located at number 35 Ate Street, General Santos City, and restore possession thereof to the plaintiff April Morales. Ordering the defendant to pay the plaintiff the amount of 50,000 pesos as unpaid rentals covering the months of July 2024 to April 2025. Ordering the defendant to pay continuing monthly rental of 5,000 pesos from April 2025 until he vacates the premises. Ordering the defendant to pay 5,000 pesos as attorney's fees and to pay the costs of the suit. Let a writ of execution issue immediately upon finality of this judgment.
So ordered.
Good. Sit down. But next time, deliver it calmly. You look so tense. So, how about suspension of action? Miss Bugayong.
According to Rule 30, Section 8 of the Rules of Court, the suspension of action shall be governed by the provisions of the Civil Code and other laws.
How many hours did you spend memorizing it? You should attend the workshop on how to recite naturally. For your information class, Section 9, Rule 30 of the Rules of Court stated that the judge of the court where the case is pending shall personally receive the evidence to be adduced by the parties. However, in default or ex parte hearings, and in any case where the parties agree in writing, the court may delegate the reception of evidence to its clerk of court, who is a member of the bar. Anyway, Ryan, do you agree that the clerk of court has the power to rule on objections to any question or admissions of exhibits?
No, I do not agree, attorney. The last sentence of Section 9, Rule 30 states that the clerk of court shall have no power to rule on objections to any question or to the admission of exhibits, which objections shall be resolved by the court upon submission of his or her report and the transcripts within 10 calendar days from termination of the hearing.
Why do you stand like that? Stand straight! Anyway, you may take your seat. That's enough for today. Next meeting, read as many as you can. Anyway, very good. Class dismissed.
Very good. Not so her.
So the paragraph,
Which shall be Are you sure? Remain standing.
The court ruled in this case.
Read many many cases.
Go.
So what's your concern, ma'am?
Kung ganito, pagkaya magulat from you.
I know and I will pay you when I have the money.
No,
I know and I will pay you when I have the money. Why you're so loud?
Me? Loud!
May be granted if it appears upon affidavit or sworn certification that the presence of such party or counsel at a trial is indefensible.
Do you promise to say the truth,
And nothing but
nothing but the truth?
I do.
do you love
Do you
him?
now take the stand?
Yan, nag-smile ko dapat and to recover the unpaid grants. Again.
Yes,
Ay, ako di ay. Balik.